Canada's foremost public interest lawyers and has been named one of the 25 most influential lawyers in Canada by the Canadian Lawyer magazine. He has also been selected as one of the University of Toronto's 100 most notable graduates of the 20th century. He is a seasoned constitutional lawyer with a positive record, and a major component of Julian's work has been involved in advocacy in human rights and public interest litigation. Julian's more prominent individual clients have included Maher Arar, who made Canadian legal history in receiving the largest human rights settlement allotted to an individual plaintiff. Also, the family of Ashley Smith, a 19-year-old who died in custody at Grand Valley Penitentiary, and Adam Nobody, the Free Press Forward, in relation to their unlawful beatings and arrests during the G20 summit in Toronto. Julian has also played a major role in the Ipperwash inquiry. Asha has acted as a number of police misconduct hearings and has appeared before the Ontario Human Rights Tribunal and Superior Court of Justice. In the past 18 months, besides working on our ERT, she has led 5 additional review tribunals involving industrial wind development and the Canadian Charter of Rights and Freedoms. Julian and Asha have been involved in litigation against the provincial government and wind energy companies since 2011. Welcome again.
Thank you. What I'm going to try to do is ensure that 2 things happen at once. First of all, that you can always hear us. You should be able to hear your lawyers, don't you think? Good. So is everybody okay back there so far? Perfect. All right. Secondly, one of the things that lawyers have a well-earned reputation for is our sizable egos. I'm going to try to make sure that mine is contained enough by ensuring my colleague Asha James, who is all humility and brains, is with me throughout this presentation. Right? Not to mention the better-looking side of the firm. We all know that. So in doing this sort of duo, I think that it's important we have 2 mics going. So that means, Ash, I'm giving you this mic. Now, you got to hold it really close. They still can't hear you.
I said thank you.
There you go. Can you hear her now?
Yeah.
All right, perfect. So I want to start by expressing my gratitude for your confidence to date and for the honor representing the different interests that are actually in this room today. Obviously, Waite represents, by way of Plimpton, Wyoming, the direct client of note tonight. The work of Elizabeth, Santo, Ingrid, Lance and Kimberly, Bryce. These folks have all directly contributed, and I'm speaking to them. But at the same time, I'm speaking to the wider audience that are here. Because, of course, this is all about solidarity in a very difficult battle. I want to thank you for the privilege of representing your interests. I get that it sucks to lose. It does. It sucks. It's a quote I took from my 88-year-old father, who says to me, "Julian, it sucks getting old." It sucks. And it sucks to lose. And I can't fix that. Like, I'm not a snake oil salesman. I'm not here to tell you losing's good. Asha and I, and Julian Roy, who's been with me for some 19 years, which obviously puts his mental competence into question. But we're a team that have very, very, very little time for losing. But it's a reality of the battles we fight. Generally, we take cases nobody else wants to take, and there's a reason. Battling government or the state at any level is not generally a winning ratio journey. If you go and gamble at a casino, and you gamble against the house, it will cause you no surprise that you are likely to lose. And it will cause you no surprise to know that the other side's working with house money. Right? And so when somebody leaves the casino a big winner, The footnote never gets properly canvassed with them, which was how many times were you in there and you lost? Right? Because when you fight certain battles or take on certain odds, there's a reason that you're likely to lose. I'm not trying to sell you on losing, I'm trying to talk realistically. As advocates, we take pride in not being salesmen or saleswomen. We are selling things, not to you, to the court. I'm not here to sell a damn thing to you. We are here to talk about your litigation and your issues and your journey in battling wind turbines. I start by addressing that issue of losing because the worst thing for you right now is any form of efforts to try to say, oh, it's okay. It's not okay. It's not okay. It's not okay that Sean has these turbines around his home. That is not okay. It's not okay that the government has passed legislation that basically permits the building of projects even if there's a reasonable prospect of serious harm. There can be a reasonable prospect of serious harm to your children or yourselves, but that's not enough to stop a project. You must actually get run over by the damn train. And so is it any wonder that ERT hearings are lost in large numbers? Now, everyone knows what the ERT stands for, right? Environmental Review Tribunal. Right? Wrong. Express Route for Turbines. That's what ERT stands for. Right? Express Route for Turbines. Now, is it because the adjudicators are corrupt? No. It's because the legislation that has been constructed is totally rigged. Its creation and drafting was influenced by very rich and wealthy interests that are now cashing in, getting the work done overseas at the cheapest rates possible to maximize profit, not create jobs, creating a source of renewable power that is dubious at best. No one is standing up and defending the efficiency of wind energy. No one is. And they don't know how it affects our health. They still don't know. Sean Drennan and his family are lab rats. And now the Bryce family become lab rats. And there are 4 kids. This isn't about some subjective, biased vision of the world. They are telling you, Health Canada is telling you they don't know. In fact, what is fascinating is they released a summary but haven't even released their study. But what they do say, and this is the best way to break down their conclusions, what they say is, if one were using an eardrum as an example, wind turbines do not physically split your eardrum. But the low frequency noise and infrasound waves can drive you so crazy as to indirectly impact your health in a whole innumerable number of ways. Now, do you care whether your eardrum is split or you have high blood pressure because you can't sleep in your own home? Does it matter?
Yes.
At the end of the day, you are having things dropped in your lap, in your yards, and the policy explanation for it is completely void of merit. We, to this day, do not understand why they have to be near your homes in a vast land like Canada, where there are literally millions of acres. But Samsung would have to pay more money. And so Samsung saves $1, and when they save $1, you have it in your backyards. That's how it works. It's very interesting to me to look at the bottom line issues Because people assume, as a constitutional lawyer, I'm going to get up here and rhyme you legal precedent. I'm not. What I'm going to talk to you about is, from a commonsensical point of view, what the legal principle is that is driving the appeal. An appeal that is now lost in the divisional court that we are seeking to appeal to the Court of Appeal. Why this impacts you is because, at the same time, in respect of the Cedar Point wind project, we are attempting to follow lockstep with our constitutional issues that we also raised at the ERT. Now, whenever I use the royal we, that's my way of cheating. Asha did all the work and then I get the credit. But, exactly. But it is important to understand that these arguments apply in all the cases we're running right now. And the argument is quite a simple one. That nowhere in this country of ours is more sacred to us than our homes. The place that we find sanctity after a day's work is our homes. When you've had to deal with that lawyer all day and all he's interested in is money, you get to go home and see your family at night. And as long as you don't have my 15-year-old son, then, I'm kidding. He's great, actually. But my point is, money and all the other stressors in your life you get to leave behind. The Supreme Court of Canada, in a case that I actually read to the court, described this notion. The house of everyone is to him as his castle and fortress. The place where our most intimate and private activities are most likely to take place. Where do you need to feel safest? In your home. At what time of day or night is it most important to feel safe? When you're sleeping in your home at night. The very moment that low-frequency noise and infrasound goes right through the walls. It isn't, does it happen anymore? The Health Canada study acknowledges it happens. Were those realities part of the setbacks of 550 meters that the province of Ontario took into account? They even admitted, no. They didn't know about it at the time. So they created setback rules on the basis of one state of affairs and then found out about the impact of low-frequency noise later, but never changed the rules. Why? I say because of the interests, the huge financial interests that these large wind turbine companies represent. And so we're advocating in the court, we're saying as a constitutional principle, the state should not be able to authorize incursions into homes this way. The safety of the citizenry, the sanctity of the home should come above these dollars. Now, we argue that as a constitutional principle in the context of a health interest. And I told you this a year ago, and I repeat it again. This constitutional argument is a long shot. The case law talks about serious harm to health. We say it is serious, others say it is not. There is a quote from an American author, and thank God the iPad can be expanded so that I can see the quote that I was so sure would be a great quote. An American poet in the late 19th century, Ella Wilcox. To sin by silence when they should protest makes cowards of men. To sin by silence when they should protest makes cowards of men. Ella Wilcox. That notion that you do battle over principles, not because you know you can win, but because it's the right thing to do, is something that infuses our work. Now, am I doing this for free? No. Do I have a conflict of interest when I talk about this because ultimately I financially gain from applying my craft? Yes. But all I can do is tell you straight up that this is a battle worth fighting, not because you're going to win it, but because I don't know of any other way of fighting these people. I don't know of any other way of fighting these interests. The only other option so far that has been presented to me is you either comply or you all turn into turtles. Just saying, that seems to be the only way to get a win out of the express route for turbines. Right? So you either comply or you turn into turtles. Both options are equally absurd. I emphasize this, that ultimately the decision is not, are we going to win? I've said before it's a long shot. The words long shot mean something. They mean the likelihood is you will lose. But sometimes the battle and the journey has important components to it. First of all, simply sitting back, resigned to what you're presented with, for people like me, and I suspect people like you, is unacceptable. So, if it's truly principally wrong, the question is, how do you fight back? So you are fighting politically, I know that, from your fine representatives. You're fighting in the courts, and you're fighting through the media, and you keep fighting, and all of this is meant to convey a message to government. Will it work? So far, they've had blinders on. So far, they've had blinders on. The large corporate interests are clearly making money hand over fist. Has anybody noticed that every single firm that represents them is a Bay Street, Toronto firm? What does that tell you? It tells you that huge dollars are involved. If not billions, certainly hundreds of millions. That's what you're fighting. There is the Ontario Court of Appeal, if leave is granted, and then there is the Supreme Court of Canada. These fights are expensive. You may choose to sit it out. There's no lack of honor in that. There's no shame. Everyone has to make that decision. We ply our trade fighting government, but it is a trade. So I'm in a conflict when I talk about this case because there is a financial benefit on the other side. But the pride we take is in how we fight our cases. Now, you need to know what happened in front of the ERT in respect to the Bryce family. Ash is going to tell you a bit about that. That is, who testified, and I'm going to, for once, stop talking and listen, because I want you to know exactly the evidence that was presented in front of the ERT, so that you understand that your case is being heard, and so you understand what's going to the next level. Asha?
Thank you. So, on behalf of the Bryce appellants, we called Kimberly and Lance Bryce, and they discussed and gave evidence before the tribunal. They gave evidence before the tribunal about their current health conditions and the health conditions of their children. And they expressed to the tribunal their concern that their two young children go to a school right next door to their farmhouse, and that their two boys would be exposed to this low frequency and infrasound noise 24 hours a day. They wouldn't be able to get any rest and recovery from the sound. We also presented the evidence of two post-turbine witnesses, Barb Ashby and Sandy McLeod. I think they're both here tonight. So Barb Ashby used to live in the Melanchthon Project. And her evidence discussed her experience when that project became operational. Barb Ashby was excited about wind turbines. When the first phase of the Melanchthon Project was going up, she was taking pictures and sending it to family and friends saying, "Isn't this great? We're going to have a wind development in my area." But when the second phase came, and that was the phase where she lived about 400 meters from the closest turbine, and that was a project that was pre-Green Energy Act. The noise from the turbines, it was immediate, the symptoms that her and her husband suffered. So, ringing in the ears, pressure, sleepless nights, to the point where Barb and her husband took their mattress out of their house, set it up in a tent in their backyard, just so that they could gain some relief from the noise from the turbines and the vibrations that they were experiencing in their house. She's since moved away from the project, and all of the symptoms that she suffered from while she was living there, she no longer suffers from. The other post-turbine witness was Sandy McLeod, and Sandy lived in the Ripley project. Sandy's family lived in that home for about 17 and a half years. That's where she planned to retire. That's where she planned to see her daughter and her children get married on their farm property. Their project was also a pre-Green Energy Act project, but Sandy was about 700 to 800 meters away from the closest turbine. And she experienced symptoms and issues similar to Barb Ashby. And that is that as soon as the project became operational, she had ringing in the ears, sleepless nights, chest palpitations, headaches. This caused her to have memory loss. She couldn't remember her students' names when she was going to school. And it got to the point where she just couldn't sleep in her house anymore. The wind company acknowledged these effects. They provided boarding at hotels in the area for those that were affected. And eventually, Sandy had to sell her house to the wind company and move and find somewhere else to live. So, and their story is not unique. I mean, these are the stories that we are being told and we're hearing from residents living throughout the province that are living in close proximity to these projects. We also presented expert evidence, and we called 3 experts. We called Dr. Arlene Bronzoff, we called Dr. Mariana Alves Pereira, and we called Dr. Jeff Aramini. So Dr. Alves Pereira is from Portugal, and for many years, probably about 20 years or more, has been involved in studying low-frequency effects in the workplace, how low-frequency and noise affects workers. And more recently, there was a family in Portugal, husband and wife and their 2 kids, and they had a farm property. And they were about 450 meters from a wind turbine project. And what they did, the Alves Pereira group, is that they studied this family, they took sound measurements, and then they also looked at whether or not they could identify any cellular changes in the body from the low frequency and infrasound that the family was experiencing. And their research showed that there was. The other expert that we called, Dr. Bronzoff, is an environmental psychologist. And the evidence that she presented to the tribunal was really how individuals experience sound. And a great example that she gave to the tribunal is that sound is all around us. We hear sound, it travels through the inner ear and the outer ear, and I'm not going to get into all the biological components of that. But what she said is your brain filters sound, and sound that is unwanted is perceived as noise. And the inability to control that noise, or that noise source, is what leads to this annoyance and these stress effects or results. And so her evidence was that the inability for an individual to turn off the wind turbine noise at night, or the inability of their complaints to be addressed by the Ministry of the Environment or the wind company, elevates the stress that these individuals are experiencing, and stress, is exhibited through cardiovascular problems, it's exhibited through, causes the sleep disturbances, and there's a bunch of indirect health effects that she provided examples of to the tribunal. Lastly, we called Dr. Jeff Aramini, and Dr. Jeff Aramini is an epidemiologist with expertise in public health. And he was called really to address the Health Canada study summary results that had come out on November 6, 2014. And Dr. Aramini was providing information to the tribunal. I'm sure everybody has heard about the Health Canada study summary results and how they said that there's no association between wind turbine noise and sleep disturbances and increased blood pressure and hair cortisol, but there is an association between wind turbine noise and annoyance, and there's an association between annoyance and sleep disturbance and perceived stress and increased blood pressure and hair cortisol. And what Dr. Aramini was trying to explain to the tribunal, and did so quite well, was that annoyance seems to be a constellation of symptoms. It seems to be the headaches, the dizziness, the tinnitus, the sleep disturbances. And everybody does not experience the exact same symptom from being exposed to the wind turbine noise. And so trying to pick out individual symptoms makes it more likely that you will find these non-associations between the wind turbine noise and a single health endpoint. And an example that he gave to the tribunal was the example of depression. He said everybody who suffers from depression, some people are depressed and they lose their appetite. Some people are depressed and they overeat. Some people are depressed and they sleep all the time. Some people are depressed and they cannot sleep. So trying to pinpoint just one health endpoint skews the results, and that he was giving evidence to say that annoyance, you have to look at it as a constellation of these symptoms, and it encompasses all of the symptoms that people have been complaining about. What the tribunal did with this evidence, so what they did with the evidence of Dr. Alves Pereira is they determined that her evidence was of little assistance and little weight to the tribunal because her study on low frequency and infrasound noise that related to that family in Portugal was very small. It only looked at 4 individuals. And because that study was looking at a particular project, it wasn't peer-reviewed. So they said that they weren't going to give that much weight. In respect of Dr. Bronzoff, they thought that the information she provided was very helpful, and they acknowledged that wind turbine noise can produce annoyance. But their difficulty with it was that Dr. Bronzoff could not provide evidence of exactly the mechanism of how it would affect the Bryce pellets. And she was unable to show this causative relationship. And in respect of Dr. Aramini's evidence, that was the same finding, that the Health Canada study has said it can't prove causation, and even though there is a statistically significant association between wind turbine noise and annoyance, and the statistically significant association between wind turbine noise, annoyance, and these health effects, because the Health Canada study said we can't prove causation, they gave it little weight. So at the end of the day, what the tribunal said is we are unable to prove that the project will cause serious harm to human health. And in respect of our charter challenge, as the divisional court decision had come out on December 29, 2014, they relied on that decision in finding that their test was compliant with the charter.
Thank you, Ashley. The point of the technical presentation of the evidence is to, first of all, be very careful to educate you on what was in front of the express, well, I guess I'm not supposed to say that, am I? Sorry, the Environmental Review Tribunal. The usage of humor should never be taken as disrespect for an administrative tribunal. So I didn't mean to refer to them as the express route for turbines. So please ignore the term express route for turbines, take it out of your mind. It was a mistake. So the Environmental Review Tribunal's decision simply follows lockstep with how individuals have been treated throughout the course of the litigation that involves the Green Energy Act since 2009. This is all very interesting. We're very sympathetic to you, but you didn't prove it quite enough. You didn't prove that your children are in pain today and can't go to school. Because if you had that one, you can win. So to be a winner, you have to be actually injured today. So everyone should stop battling the wind turbines and just get sick. Okay? That's how it works. That's the idea. This is absurd. It is absurd. It's wrong. It isn't having regard to what is the mandate of government to act in the public interest. It is clearly geared to the financial interests of these large corporations, and you have every reason to fight back. What is clear is that there is a toll to be paid for fighting back, not just in legal fees, but in vulnerability to cost orders against you. You will know that the Drennans, the Dixons, and the Croplans, when they lost their appeal in the divisional court at the end of December last year, the wind companies between them sought hundreds of thousands, over $300,000 in damages, in costs against them. And the court pared that severely down. But still, there were cost orders, and people were upset. But they were certainly nothing of the magnitude the wind companies were seeking. And you have to wonder, why would they have done that? Why would these multi-billion-dollar companies go after these families this way?
Intimidation. Shut them up. Scare everybody up.
That's right. That's right. Could you reasonably draw any other conclusion from their conduct? I don't think it's because they need the money. So it's to send a message. The people we represent will tell you, one and all, that when we meet with our clients, we talk to them about costs. We tell them that they're vulnerable to that. We did the same thing here last year. We do battle on your behalf. We advocate. And we advocate strongly. But at the end of the day, it's not me who's vulnerable to that cost order, it's you. So the decisions have to be made by you with open eyes. What I am happy to do is to be accountable. What the government is not is accountable on wind. They are not accountable at all. So you have to make them accountable. The only way to do that I know, because that's my trade, is the courtroom. I accept it's not the be-all and end-all. Declaring a winner and a loser often doesn't work. I'm not sure the wind litigation is any exception to that rule. It doesn't really work. Because in the end, The solution to this shouldn't be declaring a winner and a loser. The solution should be a government that, in an intellectually honest way, acknowledges its mistakes and takes another look at this, instead of creating winners and losers. And maybe all of this pressure and energy will create that one day. I have no idea. What I can tell you is, as long as you want us to be there for you and to fight for you, we will do it. We will be honored to continue to represent you. But at the same time, I do not in any way take away from the fact that there is great sacrifice on your part. And so, to the extent we can help, we're there to help. We are here to answer questions. Okay? So thank you very much for listening.
I'm still on. Thank you very much, Julian and Asha. That's terrific. We needed that dose of information, a lot of clarity. I think we're able to make some decisions from here where we go next. And just about ready to wrap up, I'd like to introduce two individuals from WAIT to close out this session.
Can I interrupt? I feel badly, because I said if people had questions, they should ask them. And I don't want you to think I'm the sleazebag lawyer who runs away. So I apologize for interrupting. Yeah, I made it up as I went. That's why you didn't know it. Do people have questions? Because it's really important that you feel comfortable. If you're a pro-wind advocate or a representative of the wind company, please stand up and ask your questions first. Sorry. Oh, you are? I'm kidding. And I am serious. If people have questions, I really think it's important you get a chance to hear from your lawyers.
You're only going to give me a minute? Mr. Falconer, during the process of appeal, what is your best estimate by the time that we go through all the appeal process it's going to take, roughly? And because in the meantime, they're putting these turbines in.
Absolutely. So the only word I can use is years.
Right.
This is a war of attrition. There is no good news attached to this. I often tell my clients in the 16th century, they dueled. And then, we got civilized and replaced dueling with litigation. I have clients who wish we went back to dueling. They bled faster. So litigation is a bad system. It's a bad model. So if the Court of Appeal were to grant us leave, it would probably take a year to argue the appeal. So that would be another year. And then the judgment. Now, maybe the appeal would be argued shorter than a year, but the truth of the matter is the process takes years. Supreme Court to get, and then the next level is the Supreme Court of Canada. That's another 2 years. So it's not good news. It is a battle, but as long as you appreciate that each court level takes a fresh run at it, if they're prepared to hear your case, they have to agree to hear your case. And you look at the way courts reverse lower courts, you'll understand why when we get up, we think we're fighting a whole new day, because this is a whole new set of judges. And they are free to reverse the judges before them, and it routinely happens to my benefit or a loss, depending on how I did in the lower court.
Okay. I have a couple other questions I'd like to ask you.
I'll give you one more, all right? I got other people going. Come on, let's go for it.
Okay. Does the Green Energy Act supersede the Criminal Code of Canada?
So, the short answer to your question is no. I'm not going to come up with some witty remark. The short answer to your question is no.
No. Okay. Because your associate has given us a testimonial of the Ashbys and the McLeods, but they were put at a disadvantage. Did anybody ever advise them at the time in relation to mischief under the criminal code, dealing with noise and the annoyance, which comes right from the government? We've got a ton of evidence to support mischief here. Was any of those individuals advised of that is a course of action that could be taken?
I wasn't their lawyer, so I don't know what they're advised. I can only tell you I haven't advised my clients to charge anybody with mischief. I haven't given that advice to my clients. No, I hear you, but the problem is that the legal system isn't fair. So it's not fair in that it's not very accessible. So you might look at something and think, well, this fits. Well, but to be honest with you, it doesn't. So you need a carpenter or a plumber to explain how your pipes or your house is put together. And you need a lawyer acting honorably and honestly will explain to you why the criminal code charge of mischief wouldn't make a lot of sense. But I hear you raising it, and I don't want to get into a long story with you, I'm just telling you it wouldn't make a lot of sense. Yep.
I'll take a question here.
But it's not your fault. If you read the criminal code, on the face of it, it looks like it makes sense. That's the trick about our laws. They suck. Sorry, go ahead. No, I get it. I hear you. I hear you. I'm not denying common sense. You're right.
We have one here.
Yeah.
Sir, I'm just wondering, would it do any good in the spirit of protest? Suncor has, I think we have a unique opportunity where Suncor has another division here at River Road, and they really don't like bad publicity. I don't know why you haven't had, I don't know why we haven't had 300 people down there with some witty signs and just get the media there and shame them a little bit. I think it would go a long way.
Section 2B of the Canadian Charter of Rights and Freedoms, my man, freedom of expression. It's a beautiful thing. You have to make your own decisions about whether you should be demonstrating at Suncor, but there's nothing by way of this lawyer who's telling you that you can't or shouldn't. That's very much your right in a democracy. And that's what I meant by on many fronts. You have to appreciate there's not one thing that's going to do it. You're going to have to decide what activity that you choose to engage in to fight back and to not comply. But it's for you to figure that out. But I hear you. Any other questions?
I have one.
Yeah.
As a lawyer for the appellant, and with the summary that came out with Health
Could you start over, please, into the mic so the rest of the people can hear you?
right up to my mouth, right?
Perfect.
Okay. So as the lawyer for the appellants, and the summary that came out with the Health Canada study, you've made a request to get the study from Health Canada?
Well, so they haven't actually completed the study. They decided to release the summary early for their own reasons. The folks that we work with, our clients really, have collectively worked to ask for the data, and I think we've completed that application process just in the last few weeks. It's not a simple process to be eligible for the data, so we've asked for that, but there's no study yet to ask for. Like, the study's not
How did
finished.
they come up with a summary?
So you are asking me to climb into the head of this federal government? Yeah, I fly, but I don't fly in the clouds. I fly, but I don't fly in the clouds.